The Supreme Court chamber fell quiet as Representative Jasmine Crockett stepped to the podium, her navy suit contrasting with the dark mahogany walls. Cameras focused on her composed smile, which concealed the tension in the room. Moments earlier, Justice Stephen Breyer had interrupted opposing counsel with an unexpected comment, saying he wanted to hear from her and noting that her legal analysis in the brief stood out as particularly strong. Several conservative justices shifted in their seats, while Chief Justice John Roberts raised an eyebrow. What followed would draw attention across the legal community. As Crockett opened her case file, Breyer leaned forward and addressed her directly. He acknowledged that her constitutional interpretation challenged decades of precedent in a way he could not ignore and invited her to explain it to the rest of the court. A low murmur spread through the gallery before court officers called for order. Crockett remained composed, her focus steady as she prepared to present an argument designed to address criticism and clarify her position before the court. Before continuing, remember to like and subscribe to stay informed about the latest developments in political and Supreme Court coverage. Representative Jasmine Crockett was already familiar with high-stakes legal settings. Before entering Congress, she built a reputation as a civil rights attorney in Texas, often taking on cases others considered difficult to win. Her rise from state legislator to member of Congress was accelerated by widely shared clips of her sharp questioning and her ability to explain complex legal topics in a clear and accessible way. This hearing, however, carried unique weight. The case focused on voting restrictions that critics argued disproportionately affected minority communities, an issue closely tied to her professional background. In the weeks leading up to the hearing, some commentators described her as inexperienced and questioned whether she was prepared for the setting. Others suggested that a justice like Breyer would challenge her approach directly. Justice Stephen Breyer, approaching retirement, was widely known for his pragmatic perspective and his emphasis on how laws function in practice. His careful questioning style and detailed legal writing had shaped American jurisprudence over many years. On this particular morning, observers noted a difference in his demeanor. As Crockett's case was called, he appeared especially attentive, as though he had studied her arguments closely. Court reporter Nina Totenberg later observed that his copy of the brief appeared heavily marked with notes and highlights, suggesting careful review. It was clear that Crockett had spent considerable time developing a legal argument that questioned recent voting rights decisions without directly confronting the justices who authored them. Her strategy relied on historical records and legal principles from the Reconstruction era, presenting the issue in a way that avoided overt partisanship. The stakes were significant. The court's decision could influence voting access for millions of people, particularly in communities of color. If her argument did not succeed, existing restrictive laws would remain in place, potentially shaping future elections. Some policy groups described her theory as a significant shift from established interpretations of the law. As Crockett organized her papers, several justices exchanged brief, quiet reactions. Justice Samuel Alito leaned slightly toward Justice Clarence Thomas, while Justice Amy Coney Barrett tapped her pen, appearing focused and ready to engage. In contrast, Breyer's attention remained firmly on Crockett, as if he saw an argument worth exploring further. Chief Justice Roberts formally began the proceedings, reminding her that she had 30 minutes to present her case and noting that the court had addressed similar issues in recent decisions. Crockett acknowledged his statement respectfully and indicated that her argument was intended to engage directly with those precedents. With that, she began. Her tone was calm and measured, different from the more energetic style often seen in congressional hearings. She addressed the justices directly, guiding them to Section 2 of the Voting Rights Act. She explained that the court had often interpreted this section as requiring proof of discriminatory intent, rather than focusing on discriminatory impact, setting the stage for the argument she was about to develop. Justice Alito cut in, "Congresswoman, that issue was settled 2 terms ago. Are you asking us to overturn our own precedent?" His tone carried a hint of skepticism, but Crockett did not hesitate. "No, Justice Alito, I'm asking the court to apply it correctly." She lifted a document that had not been widely discussed in earlier briefs. This statistical analysis was not available during that case. It shows that even under your test, the pattern still points to discriminatory intent that cannot be explained by any factor other than race. The room grew tense. Directly challenging a justice in this way was notable. Observers exchanged brief glances, wondering whether this was a political argument or a strictly legal one. Then, unexpectedly, Justice Clarence Thomas spoke. "Congresswoman, these statistics can be interpreted in several ways. What makes your reading the correct one?" Before she could respond, Justice Stephen Breyer stepped in. "If I may, Justice Thomas, the methodology aligns with what we accepted in Johnson v. Alabama, 1987. It appears quite sound." He then turned back to Crockett. "Please continue, Representative." The exchange drew attention. A justice was actively reinforcing her argument while she faced questioning. Reporters began writing quickly, sensing an important moment. Crockett continued step by step, building her case. She referenced lesser-known precedents, prompting several justices to review their materials. When Justice Amy Coney Barrett questioned her interpretation of a case from the 1980s, Crockett responded by citing Barrett's own 2006 Law Review article. "Justice Barrett," Crockett said respectfully, "in your article, you noted that statistical patterns of this scale can create a presumption that shifts the burden to the state to demonstrate non-discriminatory intent. I'm applying that same reasoning here." Barrett appeared momentarily surprised as her prior academic work was brought into the discussion in this way. The tension in the room increased as Crockett continued addressing each point with calm precision. She avoided dramatic language and focused on the strength of her reasoning. Then Justice Brett Kavanaugh entered the exchange. "Congresswoman, even if we accept your analysis, doesn't the state have a compelling interest in preventing voter fraud? These measures appear narrowly tailored for that purpose." It was a familiar line of questioning, one that could shift the focus toward election security. The audience listened closely. Crockett responded with a slight, composed smile. "I appreciate the question, Justice Kavanaugh." She reached for another document. "We reviewed every voter fraud prosecution in this state over the past 20 years. There were 13 cases, and none of them would have been prevented by these measures." She paused briefly, allowing the point to settle. "However, these measures would affect an estimated 740,000 legitimate voters by limiting their ability to cast ballots. If we are discussing narrow tailoring," she continued, "this outcome suggests the opposite." Justice Breyer gave a subtle nod, while several other justices exchanged quick looks. As Crockett's time began to run out, Chief Justice John Roberts, who had remained mostly quiet, finally spoke. "Congresswoman Crockett, your statistical analysis is thoughtful," he said. "However, this court has generally been cautious about intervening in state election processes unless a clear constitutional violation is demonstrated." It was the opening Crockett had anticipated. "Mr. Chief Justice," she replied evenly, "I understand the court's caution. That is why I've reserved my most significant point for last." She reached into her briefcase and produced a bound document that none of the justices had seen before. "This," she said, "is a recently uncovered congressional record from the debates surrounding the 15th Amendment. It includes statements from the amendment's authors directly addressing the type of state actions at issue here." The justices looked on with interest. Authentic historical materials from that period are uncommon, and documents that clarify original intent are treated with care. "I had this authenticated by historians from 3 universities," Crockett continued. "It shows that the framers of the 15th Amendment intended to prevent states from creating procedural barriers that would disproportionately affect newly freed citizens' ability to vote, even when those barriers did not explicitly reference race." Justice Breyer leaned forward. "May I see that document, Congresswoman?" Crockett handed it to the clerk, who delivered it to him. The tension in the chamber increased. Introducing new historical evidence at this stage could strengthen her argument or raise additional questions. Breyer reviewed the pages closely, his expression becoming more focused as he read. The other justices watched, clearly attentive to both the document and his reaction. "Justices," Crockett said as her time expired, "these records provide the constitutional grounding the Chief Justice referenced. The framers of the 15th Amendment anticipated situations like this and sought to address them." A red light signaled the end of her allotted time. Under normal circumstances, that would conclude her argument. Before Chief Justice Roberts could move forward, Justice Breyer spoke again. "Mr. Chief Justice," he said, "I believe the court would benefit from allowing the Congresswoman a few additional minutes to elaborate on this historical evidence. It is quite significant." The room fell quiet. Additional time was rarely granted, especially at a justice's request. All eyes turned to Roberts. After a brief pause, he nodded. "5 additional minutes, Congresswoman," he said. "Please focus on the relevance of this document to our current jurisprudence." As Crockett began her extended remarks, the reporters present recognized that the moment was unusual. The atmosphere in the chamber had shifted. The Congresswoman, once described by some as inexperienced, now held the full attention of the court, with one justice openly supporting further exploration of her argument. Crockett stood steady at the podium, using the extra time carefully. The document she introduced had clearly made an impression on Justice Breyer, while others remained cautious, some curious and others reserved. "Justices," she began, her voice clear and measured, "please turn to page 37 of the congressional record." She paused briefly before continuing. "Here, Senator Charles Sumner, one of the architects of the 15th Amendment, states, the amendment must not only prohibit explicit racial barriers to voting, but must also empower Congress to address procedural mechanisms that achieve indirectly what states cannot do directly." Turning the page, she continued. "And here, Representative Thaddeus Stevens adds, a state may claim a neutral purpose such as preventing fraud, yet design requirements that place heavier burdens on freed men. The amendment must reach such measures." Justice Thomas leaned forward again. "Congresswoman, while historically informative, how do these remarks change our analysis, given that this court has consistently held that disparate impact alone cannot invalidate election regulations?" Crockett nodded slightly. It was a question she had anticipated. "Justice Thomas, that is precisely why these records are important. The framers of the 15th Amendment did not limit their concern to explicit racial discrimination. They also addressed facially neutral procedures that create unequal burdens." She paused briefly, making eye contact with the bench. "I am not asking the court to rely solely on disparate impact. What these records suggest is that the original understanding of the amendment included what we would now describe as a burden-shifting framework, triggered when certain statistical thresholds are met." Justice Breyer's expression sharpened with interest. He turned to a page he had already marked. "Congresswoman," he asked, "are you referring to Senator Howard's remarks on page 42? Crockett allowed a slight smile. He had located the passage on his own. "Exactly, Justice Breyer. Senator Howard proposed that when a voting procedure reduces participation among black voters by more than one-third compared to white voters, the state must provide a compelling and necessary justification. That standard closely resembles what this court applies in other constitutional contexts." Justice Amy Coney Barrett interjected. "But Congresswoman, even if we accept that this reflects the original understanding, the court's jurisprudence has evolved over more than 150 years. Are you suggesting we move away from decades of precedent?" "Not at all, Justice Barrett," Crockett replied calmly. "I'm suggesting that this historical evidence shows how the court's current approach may have moved away from the 15th Amendment's original intent. Returning to that foundation could bring greater consistency to voting rights doctrine." She then presented a chart from her brief. "This analysis shows that applying the original understanding would affect only a limited number of voting restrictions, specifically those with the most significant disparate impacts. Most election administration laws would remain unchanged." Justice Brett Kavanaugh, now more focused, pursued another line of questioning. "Congresswoman, even if we find your historical analysis persuasive, what is the limiting principle? Would this approach invalidate all voter ID laws?" "Not at all," Crockett answered with confidence. "Only those that meet the statistical threshold and where the state cannot demonstrate a necessary and compelling justification. Many voter ID requirements would remain valid, particularly where states provide free IDs and ensure fair access." She continued addressing concerns directly, responding to each point before it could become a barrier. Observers in the gallery watched as she methodically answered every objection with clarity and precision. Chief Justice John Roberts, known for favoring narrow rulings, raised a question. "Could we resolve this case on narrower grounds without reconsidering the broader voting rights framework?" Crockett recognized the opportunity. "Yes, Mr. Chief Justice, that is possible. The statistical evidence alone, under existing precedent, could support a ruling in our favor. However, the historical record gives the court an opportunity to bring clarity to an area of law that has become increasingly complex for lower courts to apply." The courtroom grew quiet. Justice Breyer, who had been reviewing the historical materials during her extended time, closed the binder and looked toward his colleagues. "I have spent nearly 3 decades on this court working to understand the original meaning of our Constitution's voting protections," he began in a steady tone. "And I must say, I have not encountered historical evidence this persuasive on this specific issue." His statement carried weight. Known for his pragmatic approach, Breyer's acknowledgement of an argument grounded in original intent spoke directly to the interpretive methods often emphasized by conservative justices. "Congresswoman Crockett has presented historical material not previously considered by this court," Breyer continued, and has shown how it can fit within our current framework without causing the level of disruption some might anticipate. Justice Samuel Alito, appearing uncertain, responded, "Justice Breyer, are you suggesting we reconsider a decision from just 2 terms ago based on a document that was not part of the original briefing?" Before Breyer could respond, Crockett spoke. "Justice Alito, I'm not asking the court to overturn its prior decision. That case required proof of discriminatory intent, and I accept that standard. What I'm showing is that the statistical evidence in this case satisfies that requirement when properly analyzed. The historical record helps explain why this approach is consistent with the Constitution's intent." Her response reframed the issue, respecting precedent while offering a path for the court to rule in her favor without reversing a recent decision. Justice Breyer nodded. "Exactly, Justice Alito. This would not involve overturning precedent, but rather applying it with a fuller understanding of the constitutional context." By this point, the atmosphere in the courtroom had shifted. What began as a routine presentation by a relatively new member of Congress had developed into a detailed discussion of constitutional interpretation, with one of the court's most experienced justices openly engaging with her reasoning. As Crockett's extended time came to an end, Chief Justice Roberts addressed her again, his tone measured. "The court appreciates your thorough presentation, Congresswoman." Crockett gathered her documents, exchanged a brief nod with Justice Breyer, and returned to her seat. Opposing counsel approached the podium, appearing less certain. The state's attorney had prepared for more traditional arguments, not one centered on historical interpretation supported during questioning. In the press section, reporters quickly began sending updates. An uncommon moment had just taken place, and early headlines were already forming, noting the unexpected alignment between Crockett's argument and the court's discussion. What followed in the justices' private conference would prove equally significant. 3 days later, the Supreme Court's press office issued an unusual announcement. The court had requested supplemental briefs addressing the historical evidence presented by Congresswoman Crockett. Legal scholars across different perspectives recognized this as a notable development. The court rarely seeks additional materials after oral arguments, and when it does, it can signal a deeper examination of the issues. Inside the court, the effects of Crockett's presentation continued. Reports from individuals familiar with the process described the post-argument conference as more intense than usual. One account suggested that Justice Breyer emphasized the importance of carefully considering the historical evidence. Meanwhile, on Capitol Hill, Crockett returned to find strong media interest. Major outlets, including CNN, MSNBC, and Fox News, requested interviews. Her social media following grew quickly, with discussions about her argument spreading widely. "I presented the facts and the law," Crockett told reporters. "The Constitution does not belong to any one group or viewpoint. Its protections apply to all voters equally, regardless of race or location." Initial reactions in some media outlets were cautious, with some commentators framing her appearance as largely symbolic. However, legal experts from a range of perspectives offered more detailed assessments. Some noted that her presentation combined historical research with constitutional analysis in a way that would be difficult to dismiss. Similarly, scholars who focus on original meaning found the newly discussed 15th Amendment debates both interesting and potentially relevant to modern interpretations of voting rights law. Within the court, perspectives appeared to vary. Reports suggested that Justice Thomas had asked his clerks to examine the historical materials and verify their context. Justice Barrett was also said to be reviewing the statistical arguments alongside the historical framework presented. 2 weeks after oral arguments, Justice Breyer spoke at a judicial conference at Yale Law School. While he did not reference the case directly, he discussed constitutional interpretation more broadly. "Sometimes," he said, "we encounter moments in our jurisprudence when new evidence or analysis challenges established views. In those moments, intellectual honesty requires us to consider whether precedent remains aligned with the Constitution's original meaning. This is not about politics. It is about fidelity to the law." Many in attendance understood the broader relevance of his remarks. Outside the court, public discussion continued to grow. Voting rights organizations expressed support for Crockett's position, and public events highlighted the importance of the case. Public figures also shared their perspectives, contributing to wider awareness. At the same time, some political leaders criticized her approach, describing it as an effort to expand federal authority over elections. When asked about the specific historical materials, however, responses were sometimes limited, with some acknowledging they had not reviewed the documents in detail. 3 weeks after the arguments, further reporting added to the discussion. A detailed investigation confirmed the authenticity of the historical materials Crockett had presented. The documents were traced to a previously uncatalogued collection connected to Frederick Douglass, who had been present during debates surrounding the 15th Amendment. The findings drew additional attention to the case and its potential implications. Around the same time, Justice Clarence Thomas spoke at a legal event and emphasized the importance of original meaning in constitutional interpretation. Without referencing any specific case, he noted that when clear historical evidence is available, courts have a responsibility to consider it carefully, even if it requires re-examining existing interpretations. Legal analysts noted the significance of these comments and discussed what they might indicate about the court's approach. 45 days after oral arguments, the Supreme Court announced that it would release its decision the following Monday. The length of the delay suggested that the justices were carefully considering multiple perspectives. The evening before the decision, Crockett appeared on a national television program. "Whatever the court decides," she said calmly, "I believe this discussion has already influenced how we think about voting rights. These are not abstract legal questions. They affect whether people can fully participate in the democratic process." Monday morning, crowds gathered outside the Supreme Court hours before the decision was released. News networks went live and court blogs struggled under heavy traffic. At exactly 10 a.m., Chief Justice John Roberts began reading the opinion. In a 6-3 decision, the court rules in favor of the petitioners, he announced, sending a wave of reaction through the courtroom. Crockett had prevailed, and at least one conservative justice had joined the majority. Roberts continued, "While this court has previously held that proof of discriminatory intent is required to invalidate voting procedures under the 15th Amendment, the historical evidence presented in this case provides important context for understanding how such intent may be established." He explained that the court was adopting a modified framework. When statistical evidence shows a significant disparate impact on minority voters, the burden shifts to the state to demonstrate that its procedures serve a necessary and compelling interest. This approach, Roberts concluded, aligns with both recent precedent and the original understanding of the 15th Amendment, as reflected in the congressional debates surrounding its adoption. Justice Stephen Breyer delivered a concurring opinion from the bench, a step typically reserved for decisions of particular importance. Today, the court shows that faithful constitutional interpretation is not limited to any one judicial philosophy, Breyer stated. Representative Crockett's careful historical research and legal reasoning remind us that the Constitution's protections for voting rights are both meaningful and enduring. In a separate concurrence, Justice Amy Coney Barrett, joined by Justice Brett Kavanaugh, wrote, "The statistical framework developed by the petitioners, considered alongside the historical understanding of the 15th Amendment, offers a balanced approach. It protects both the role of the states in administering elections and the individual's fundamental right to vote free from discriminatory barriers." Justice Samuel Alito, joined by Justices Clarence Thomas and Neil Gorsuch, dissented. "Today's decision represents a departure from recent precedent," he wrote, relying on historical evidence that, while noteworthy, should not override established jurisprudence in this area. As news of the ruling spread, Crockett's phone filled with messages. President Joe Biden called to congratulate her on the outcome. Civil rights leaders described the decision as one of the most significant voting rights rulings in recent years. Law schools quickly began adding the case to their constitutional law courses. When Crockett stepped outside the courthouse, a large crowd had gathered. Supporters applauded as reporters called out questions. She raised her hand, signaling for a moment of quiet. "Today the Supreme Court reaffirmed a fundamental principle," she said. "The Constitution protects every American's right to vote. It does not allow systems that limit that right under the appearance of neutrality." She paused before continuing. "This outcome is not about one individual. It reflects the experiences of many people. The senior who cannot easily access identification. The parent who cannot wait in long lines. The student whose polling location has changed. These are the voices at the center of this issue." Later that evening, as she returned to her office, Crockett found a handwritten note waiting on her desk. She recognized the handwriting immediately as Justice Breyer's. "Representative Crockett," it read, "in my years on the court, I have rarely seen advocacy that brings together historical insight, constitutional clarity, and practical understanding in this way. Your work has shaped this case and may influence the direction of voting rights jurisprudence for years to come. The Constitution and the country are stronger for your efforts. With respect, Stephen Breyer." Crockett carefully folded the note and placed it in her desk. Turning to her team, she spoke simply. "We've made progress, but the work on voting rights continues. Let's keep moving forward." In the months that followed, the impact of the ruling became clear across legal and policy discussions. States with restrictive voting laws began reviewing and adjusting their systems. Legal journals published detailed analyses of the court's updated framework. Scholars developed case studies based on Crockett's approach. Crockett herself became a widely recognized figure, often invited to speak on constitutional issues. The congresswoman who had once been described as inexperienced was now leading discussions at major universities on effective legal advocacy. A year later, Justice Breyer announced his retirement. During his farewell remarks, he reflected on the case. "Even after many years on the bench, judges continue to learn," he said. Representative Crockett reminded us that constitutional interpretation requires both humility and thoughtful judgment. Her advocacy in that case remains a meaningful part of my time on the court. When asked about his comments, Crockett responded with a smile. Justice Breyer showed us that while the Constitution endures, our understanding of it must remain thoughtful and grounded. When legal reasoning is approached with care and integrity, the system works as it should. She added, "I'm grateful I had the opportunity to present a case that reflected those principles." The story of Jasmine Crockett and Justice Stephen Breyer would go on to be studied in legal circles. It serves as a reminder that a well-prepared argument, presented at the right moment, can influence how constitutional principles are understood and applied. Thank you for watching this story about how careful legal reasoning and thoughtful advocacy shaped an important moment in constitutional law. Don't forget to like, subscribe, and turn on notifications for more stories about law, policy, and the people influencing the legal landscape.